right, good afternoon, everyone. Welcome to this meeting of the General Policy Committee of the Gainesville City Commission for Thursday, September 25th, 2025. Where did the year go? All right, Madam Clerk.
Mr. Mayor, we have the adoption of the agenda.
So moved.
Second.
We have a motion and a second to adopt the agenda as printed and distributed. All in favor, I see no lights. All in favor, please say aye.
Aye.
Aye. Any opposed? All right, that passes unanimously with Commissioner Chestnut absent. Madam Clerk.
Mr. Mayor, we're on to the approval of the minutes with the recommendation the General Policy Committee approve the minutes from the September 11th, 2025 meeting.
So moved.
Second.
We have a motion and a second to adopt the minutes of the September 11th, 2025 General Policy Meeting as printed and distributed. I see no other lights. All in favor, please say aye.
Aye.
All opposed? All right, that passes unanimously with Commissioner Chestnut absent. Madam Clerk.
Mr. Mayor, we're on to 2025-746 Interim City Manager Employment Agreement with the recommendation the General Policy Committee approve the employment agreement with Mr. Persons and authorize the mayor to execute the agreement subject to approval of the city attorney as to form and legality.
Very good, thank you. So per the direction of the commission about 3 weeks ago, I did meet with Mr. Persons, and we have a draft agenda in your backup, and Ms. Gretz will tell us more about it.
Good afternoon, Mayor and Commissioners. Laura Gretz, Human Resources Director. Happy to be with you today. The item you have before you is an agreement that was negotiated by the mayor with Mr. Andrew Persons. I just want to provide you with some information to help the mayor prepare for his negotiations. I provided some information that he could use for those discussions. In terms of salary, just for your awareness, we have a pay range for the city manager position with a minimum of $227,826, a midpoint of $296,174, and a maximum of $364,522. We also took the time to survey cities around the state of Florida. We received information from 41 of those cities, and the average city manager base salary was $268,561. Keep in mind, these are all different jurisdictions, all different levels of experience for each of those city managers. To put in context the offer that has been used for this agreement, the offer of $245,000 falls within the first quartile of the pay range for the city manager position. The only other thing that's a little bit different than some of our interim agreements is because Mr. Persons is a current employee of the city, there are provisions about him rolling back to his current position should this engagement end for some reason. So with that, I'll take any questions if you have them.
Anyone? Commissioner Willits.
Mr. Mayor, just so I know, Ms. Gretz, so the rolling back to city employment, does it leave that position open and funded through this budget, obviously through this budget year, or rather, well, I shouldn't say obviously. I'll leave my question there.
Okay. So yes, Mayor and Commissioners, it would leave that position open. So essentially, Mr. Persons still occupies that chair or seat, but he's acting or sitting in the chair of interim city manager. So it stays open until such time that any permanent arrangements were made.
Okay, and the agreement, just so the salary starts on November 22nd, or does it start
Oh,
now?
yes, thank you, Commissioner Willits. So yes, Mayor and Commissioners, when the decision was made to appoint Mr. Persons to this position, the request was that the position, he started in this role October 21st. That day, just for semantic reasons, falls on a Tuesday. For payroll purposes, you'll notice in the agreement we have the start date of October 20th, and that's purely for payroll purposes.
Okay, thank you, Ms. Gretz. Thank you, Mr. Mayor.
Thank you. Commissioner Book.
Yeah, thank you, Mr. Mayor. I appreciate the work. I appreciate the fact that while Mr. Persons is clearly qualified, we are paying in the lowest quartile, which is what you said. I think that's appropriate. But you also have a manager in Mr. Persons that's had significant, over a decade of higher management experience. So that seems to fit exactly with what you put there. I did have a question. I spoke to the city attorney. The bottom of page 5 and the top of page 6 deals with termination for cause. Now, I think the chances of this applying to Mr. Persons is none and none. right? But this is a templated contract. And so when you look and going forward, we always want to make sure that we're handling our top-level employees as role models for the same way we would handle all other employees. And Mr. Attorney, your brief conversation with me dealt with, there's some termination for cause language related to a crime. If someone commits a crime and it indicates they'll just roll back to their position, could you kind of talk a little bit about that, Mr. Attorney?
Absolutely. Thank you, Mr. Mayor. And I appreciate Commissioner Book reaching out to me in advance so we have a moment to look specifically at what its concerns are. And I think if you look to the contract, and it is a term that has been, I think, standard, and you've had several interim contracts like this before, so this isn't the first time it was drafted for this. But that paragraph C on the bottom of page 5, what it addresses is in the event that his appointment as the interim city manager is terminated for cause, as stated by at least 4 members of the commission, then it should be returned to his pre-employment position. And it gives examples of cause, which cause, some examples, non-inclusive list, includes explicitly gross negligence in the handling of city affairs, willful violation of the provision of law, willfully disregarding a direct order or demand of the city commission or a policy of the city, conduct unbecoming an interim city manager, pleading guilty or nolo contendere to or being found guilty by a jury of a misdemeanor involving physical violence, theft, driving under the influence of drugs, possession of sale of drugs, or other felonies. And I think it's important to note what this provision is talking about are cause conditions for which the commission would terminate this appointment as interim city manager. And it would roll back to his position as an employee, wherein he would still be subject to all of the rules and regulations related to our employees, such that, and that provides for, under our human resources policies, discipline or sanctions upon offenses being found that are both equitable across people and over time, and also progressive for the individual. So as you could expect in the employment context, this is dealing with the appointment context. In the employment context, things such as conviction of a felony might lead to immediate termination of employment, but something such as conduct unbecoming interim city manager, depending on what it is, might result in a sanction for a chief operating officer, but not necessarily termination. This provision deals with the appointment to interim city manager and doesn't, I think, implicate the responsibilities that all employees have under our employment policies, HR policies.
Yeah, so my concern there was, I appreciate, especially the research that you did was, we have somebody who commits an act of domestic violence in any position. This is, again, this does not apply to Mr. Parsons. This is not going to occur, but it is a templated contract that we have to be very careful with, and we want it to be as defendable as possible. So someone committed an act of domestic violence, in the way that this paragraph reads, what we would do with that position is we would then put them back in their previous position. As the city attorney said, it appears that then other processes and HR protocols and policies, which could then also be put on top of that, but it doesn't read that way. It simply talks about put that person back, and I can't imagine we'd have somebody who would commit an act of physical violence, so we say, no problem, at the moment, you're back in your formal position. And so we just need to be careful about our contractual. We probably need to split that in some way, shape, or form. Is there any language change you would recommend, or do you feel this is absolutely defendable as it is? Because I wouldn't put anybody who committed an act of domestic violence back in their former position. We would determine whatever processes go on, and we would move forward.
And again, Mr. Mayor, this contract is as to the appointment for interim city manager. That's something that really is going to be within the discretion on a contractual basis with this body. If that contract is terminated by a vote of 4 of the 7 members for any of these cost provisions, then at that point, the continued employment of the individual really isn't under the purview of the commission. Then at that point, he is an employee, and he is held to all the responsibilities of an employee and all of the rights of an employee as well, such that we unfortunately might have individuals who get convicted of misdemeanor offenses that are certainly not ideal, but not necessarily terminable, depending upon their position. That being said, for a COO, I imagine that bar is still, your expectations are much greater than they are for someone with less supervisory and less forward-looking responsibilities representing our city. But still, that would be a consideration for human resources and their employment rights and responsibilities. This contract deals with the appointment to the charter officer position on an interim basis. And I hope that makes sense. And if we need to adjust the language to make sure you have a level of comfort, then absolutely, please give us that direction, and we'll work to get the language that better satisfies you and better embraces what the commission intends in these contracts.
But my thought was just as if the contract as reads allows us to be completely defendable for all actions as it currently reads, then I'm okay with that. But I do think that we probably need to clean that up for future contracts, and that could be a motion post the interim manager. I consider those two different things. But we do need to, I think, clean up a little bit of language about conduct. We wouldn't allow our frontline employees to come in and act a crime and then go to some other position, and we need to be the role models and set the example. So the higher you go, the more accountable you are. And but if you feel like this is completely defendable as it reads now and still allows HR processes to go complete, again, I only said this a few times because I don't want Mr. Persons to think this way. This is not going to occur with this employee. This is a top level, top manager, ethical employee. But it is something that we have codified, so we always need to be careful with those. That would be my thought, is you're completely okay with the language as it reads and being defendable for those types of actions.
Yes, Mr. Mayor. Again, this is a contract for the appointment to an interim charter officer position, the interim city manager position, and I feel it satisfies those requirements and it's consistent with what we've done in the past. If there is a desire to change the language, even if it's just not substantive, but more just to improve the verbiage so that it's understandable, then we can do that now with this agreement. We can do that in contemplation of future agreements, whatever the direction may be.
Thank you. I'll wait to hear from my colleagues and what their thoughts are.
All right. Thank you, Commissioner Book. Commissioner Chestnut.
Thank you. I think the more the attorney talked, the more confused I became.
I'm sorry, if I might try to boil it down a little bit into non-attorney speak. If we fire, under this contract, if we fire Mr. Persons from the city manager job, somebody will be acting city manager pretty much immediately because we have to have an acting city manager, and that person would have a responsibility to enact discipline on Mr. Persons, who would then become his employee.
Okay,
Is that
but I
accurate?
think it needs to be clarified. It needs to be in layman's language in the contract.
And Mr. Mayor, that's if you look at, again, paragraph C at the bottom of page 5, in the event Andrew Persons' appointment as the interim city manager is terminated, not his employment with the city of Gainesville, because again, this is one of these situations we have where we have a long-term employee who is accepting the interim appointment. And the idea being that if the standard for a city manager, for the appointment to the interim city manager, isn't met in the eyes of the commission, be it for cause, then that appointment will be pulled by the city commission. But this person, being a longtime employee, still is an employee, and then as the mayor stated, it's up to the new manager to handle the personnel below them in accordance with our rights and responsibilities as established in your HR policies.
I think just make it clear.
We can
Make it clear.
we
in
can
the
make that
contract.
effort.
Would that in any way affect the appointment time? But the attorney to take this back and clear up the language.
My guess is yes.
Well, how long would it impact it?
So, Mayor and Commissioners, so we work in partnership with the City Attorney's Office for the drafting of the language, so I would defer to City Attorney Nee for the quick turnaround, if I may, and I don't want to muddy the waters. If I think what I'm hearing correctly is the desire from at least a couple of the commissioners who have had a chance to speak, is that there's perhaps a sentence that is added to this paragraph that might indicate that should the interim city manager be removed from his post of interim city manager for cause, he is still subject to the code of conduct within the city of Gainesville and the associated process that goes along with that. Something, Mr. Need could come up with something far more eloquent than what I just said.
We could drop a sentence at the end of this paragraph that says if the appointment is terminated by cause, the individual's employment will still remain subject to the human resources policies and all rights and responsibilities under there. I mean, something like that might satisfy your concern, just to make it clear that, again, the first sentence only talks about the appointment. We can wrap it up by saying the employment in the reverting role is still subject to our HR policies. And that's a quick little addition of a sentence that you could either authorize us to make that change and for the agreement to be signed by the mayor, or we can direct us to make that change, and we'll make it and bring it back at a time if you want. Whichever the board is comfortable with.
Oh, wait,
All right, Commissioner Eastman.
Or leave it.
Do you think that's a material change in terms of this, or it's just a clarifying?
No, I think the agreement says what I tried to explain that it says, is that it deals with the appointment. And that's the unusual situation here. It's not that unusual, frankly. It's the situation I was in, the situation Mr. Cunningham was in, I think Mr. Folston was in, where...
Ms. Bryant.
Absolutely, where it's not unusual at all, I guess. I should correct that. But where a long-term employee is being selected to be the interim charter officer, and it's a recognition that they may not want to jeopardize their employment by taking the interim assignment. And that if the interim assignment goes away for any reason, for no cause is dealt with in the preceding paragraph, and for cause is dealt with in this paragraph. And there are certainly things that would get me dismissed now, for example, for cause, that wouldn't necessarily back before I was a charter officer. There are convictions of misdemeanors that, while are certainly serious, I would take any crime that I was charged with or convicted of seriously, but that we do have valued employees who have made mistakes and have been convicted and still fill their roles. It's not going to necessarily jeopardize their employment. Now, a COO, I think even relatively minor infractions, you're probably, the manager's probably not going to abide by much by the way of unlawful activity. But that being said, this contract deals with the appointment to the interim city manager and as opposed to the overall employment of the individual.
Very good.
Well, yeah, I mean, I guess what I would say is that this is very different than the appointment of a city manager, right? So when someone continues to move up the chain of command, you end up, I think once you're in the administration, are you still under, you don't have the same kind of civil service protections, right, that you would have at a lower level.
Mayor and Commissioner, it depends on the position. If they're defined as at will, then yes, that protection is.
Right. And then one of the things is everyone knows that sat up here and watched any history of the city of Gainesville, then you make a decision to go one step above that, and then you lose even more of those civil service protections, right? And so this is sort of an in-between phase. So you still have the protections of at least being within the administration. You're still at will, I would imagine, for the chief operating officer role. But then if we were to let you go for these defined levels for cause, then you would just be knocked down to that next level. So you're still there. You're still, because this really is just someone taking over the reins during an interim time period. This is not the city manager. This is someone who is just taken over as our current city manager is stepping aside and then moving into the role. So, I mean, if we want that clarifying thing in there, it doesn't sound like that would add a lot of time, but it doesn't sound like it's material at all. This is more just something that you had noticed within there that is that's within the contract, right? It's just it's just an interesting.
We would take that as direction that the commission wants us to clarify what's already here and make that clarification. And again, you can either, I do think it's not material such that you could authorize us to make that change and have the agreement signed, or just as easily authorize to make that change and we'll put it on the next consent agenda or speaking agenda, whichever you prefer.
I mean, I'm comfortable with it. It doesn't seem like it would make it wouldn't make any really significant change or really any material change at all to it. And it's and so I'm fine just going forward with what we have here, and then, we'll have that, the full-time city manager at some point, which then I'm sure we'll have stronger protections within there. So I'm fine with it. That's my 2 cents, Mr.
Thank you,
Thank
Commissioner Eastman. Before I go back to you, Commissioner Book, let me correct one thing. While this contract and our general conversation, the general understanding contemplates an interim position, the charter does not contemplate interim positions. The charter says city manager. So let's be real clear about that. When we hire an interim city manager or any of our other 4 charter offices as an interim, they are fulfilling that office per the charter, not an interim position. Now, the contract affects that and puts other guidelines in place around that. But per the charter, there's no difference between interim and an actual permanent person holding the position. That has nothing to do with what we're talking about here, but it's an important note because this won't be the last time we do this, and I want everyone to be fully aware that when we hire an interim, until we replace that person with somebody else, that is the charter officer in that position. So just wanted to note that. Commissioner Book.
Yeah, I thank you. Given what I've heard, I think there's absolutely no downside to clarifying language that says that we set the example in the bar high, and that we follow the same rules and policies and procedures of every staff member, regardless where they're at in the organization. And as we know, us sitting up here, we should be held to a higher standard, and our department heads and our charters are held to a higher standard. So I think it, from an optic perspective, and I don't normally think from optic perspective, but from that, I think it's a good clarification. And it also will allow us moving forward to have that same language, whether someone's in a permanent position or not. We don't want to be able to, the way that people would look at this would be, you commit a crime, you go back to your former position. And that is what it says. And while it is an appointment, the fact that there's no material change, but quick and easy, I think is probably good. I think it sets the right tone for us as leaders. So with that, I move approval of 2025-746. Recommendation, General Policy Committee approve the employment agreement with Mr. Parsons, subject to some minor clarifying language related to protocol and policy as discussed by the city attorney, and authorize the mayor to execute the agreement subject to approval of the city attorney as to form and legality. Mr. Parsons is going to do an incredible job. This will never apply to him, but I think it's the right message.
Thank you, Commissioner Book. I would ask that before we get a second, let's work out what the language is instead of some language. If we're making a direction, let's direct it, because this is the contract we're talking about. So, sure.
That suggests that the attorney or someone from the attorney's office work out the language and bring this issue back at the end of the agenda. Then we can have the language before us, see it, and then be able to vote on it.
Certainly okay with me.
Is that okay?
Oh, that's an excellent idea.
Okay. Commissioner Engel.
Commissioner Chestnut beat me to it.
Okay. Commissioner Willets.
Just on the same topic, just so I understand, because the charter does not talk about interims. So on October 20th, Mr. Parsons will be in all legal effect, the city manager, correct? It's just that we will hopefully also have the benefit of the sage advice and wisdom of Manager Curry until November 21st. Okay. I just want to make sure I understand it. So because there's no such thing as interims, so everything else applies. So Mr. Parsons has to reside in the city per the charter. I already know he does, but all right. So I'm good with that. Thank you, Mr.
Thank you, Commissioner Willets. I do want to ask Mr. Attorney or Madam Clerk or whoever is the right person for this. My understanding is that that part of the language is the same as Mr. Nee's contract as interim, as Ms. Bryant's contract as interim, Mr. Folson's contract as interim, and who am I missing?
Cunningham.
Pardon?
Mr. Cunningham.
Mr. Cunningham
You wanted
and
employees.
Ms. Anderson when she was interim auditor, I believe.
And just as Commissioner Book has indicated that there's no expectation that any of this for cause would ever apply to Mr. Parsons, this isn't the provision that was asked for, I don't think specifically by Mr. Parsons either. This is the agreement that we've used in this situation before, so. But to the extent it can be clarified, it will be clarified.
Do you feel comfortable that you can get that somebody can get that change done
I'll get that
before
done
we get
tomorrow.
to item the 5th?
Yes.
Okay, all right, thank you. All right, thank you, Ms. Gretz. We'll revisit later. Madam Clerk, I'm sorry, go ahead. Commissioner Engel.
So I thought what Commissioner Chestnut suggested was that we just bump this to the end of the agenda because all he's got to do is scribble things. So we're not talking
Yes.
about tomorrow, we're talking about the end of this meeting today, correct?
Right, the end of the agenda today.
Okay, sorry. Very good, thanks.
Madam Clerk.
Mr. Mayor, we have 2024-834 Public Right-of-Way Ordinance Updates with the recommendation, the General Policy Committee hear a staff discussion on the issues, direct the city attorney to draft appropriate modifications to the ordinances, and authorize the city attorney to advertise the ordinance modifications for first and second reading.
So welcome, Mr. Bannon. Before we get to you, let me ask, before we move on, is there anything else anyone wants to change about that contract before we get to the end of the meeting? Because now's the time, I feel like. Okay, all right. Go ahead, Mr. Mann.
Mr. Mayor, members of the commission, Phil Mann, Special Projects Administrator in the City Manager's Office. A little background. Last spring's legislative session, 2024, the state passed Florida Statute 125.023, which is regarding public sleeping and public camping. The City Commission then, in December of 2024, adopted an ordinance that allows GPD to enforce the state statute. Back when we did this, one of the conversations that staff had with the commission is we would work under the ordinance and then see if there was any recommended modifications and then bring them back and suggest or recommend them to the city. And for the most part, the ordinance, which is section 23104, which I have here on the overhead, has worked well. The one issue that causes the enforcement agencies the issue is the word overnight. And where it becomes an issue is overnight is not defined. So when they encounter somebody camping in either the public right-of-way, a public park, or on public property, when exactly is overnight? And so it has at times created a resource issue for GPD, whereas they've had to go back out a second time to when they feel it defines the overnight. So when we met when the overnight definition was met to be able to make the people camping in the public right-of-way move along in accordance with the state statute. So it's actually a pretty simple request. It's simply to strike the word overnight in two places in the ordinance. And the first one is residing overnight in a temporary outdoor habitation or residing overnight in an outdoor space without a tent or other temporary shelter. And that will allow the police department to, when we receive the complaints in conjunction with state statute, that will allow them to immediately go out and address the issue and not necessarily have to wait till overnight to come back and address the issue. And elsewhere in the ordinance, it does say it is unlawful for any person or entity to engage in public camping or sleeping on any public property or right-of-way. And so on the first part of my presentation, that is staff's recommendation that the commission refer to the city attorney's office to review this ordinance and bring back appropriate modifications.
Okay, thank you, Mr. Mann. Commissioner Willetts.
Mr. Mayor, can you go back to the part about, so all sleep, that's already in the ordinance. All sleeping is already banned. It's unlawful.
Yes, this is the exact ordinance. I printed it straight out of the manual.
God forbid I ever fall asleep in the beautiful sun rays of a November day or a March day out on the plaza.
After we revise the plaza.
Was the sleeping part advised by state law or indicated by state law?
Both the camping and the sleeping is in the statute.
Okay. And then why not just define overnight instead of deleting it completely, if the question is about the definition of overnight?
And that's why we wanted to have this discussion today, Mr. Mayor, is to see what the commission would like to do, how they would like to bring it forward, whether remove the overnight, define overnight further in the definitions, but make it a better resource for GPD to use when we have to enforce this ordinance.
Okay, so I think we have some definitions that intimate what overnight is. As far as our parks, our parks close at certain times. Some of them lit parks versus not lit parks. Staff would have to answer. Some of ours merely dusk. I can't remember exactly which ones are which, but I feel like if we have rules for parks that get to the idea of what is night, what is a time period where we're no longer actively patrolling or providing, services at parks or protecting parks in the same way, that we could line it more in line with parks and not merely strike overnight. That's a thought. Thank you, Mr. Mayor.
Thank you, Commissioner Willetts. Anyone else have thoughts on this? Commissioner Engel?
I realize there's state statute that drives quite a bit of this. And I'm not sure exactly what the requirements of that state statute are. But I don't want us to get to the point where if somebody is, if one of our homeless neighbors is asleep in a park during the day, not bothering anyone or anything else, they can be harassed or arrested or moved on or anything else. I mean, I feel like people exist and we can't legislate them out of existing. I don't know the legislation word for word, and I'm not sure exactly how far we have got to go to comply with that, but I certainly don't want to go any further than we need to on some of these things. So again, for somebody to fall asleep on a picnic blanket or a park bench or anything else out there, I don't think needs to be a crime. That's where I am on it.
Thank you, Commissioner Engel. Commissioner Chestnut?
Have we looked at how other cities are implementing this language or making adjustments?
In my discussions with the city attorney's office, I have not heard of any adjustments made, but that's not something that I would follow. That would be something we would have to rely on the attorney's office.
Oh, I see.
Okay.
Well, it may be worth looking at, just looking at some other cities to see how they have adjusted to the language since it's required by the legislature, or how they have defined it. So that would be my recommendation, is to defer this and send it back to the attorney's office to see if there are other cities that we could look at that have perhaps addressed this issue.
Mr. Mayor, if I may, this was the matter of a great deal of discussion back, I think, in December. And the law has changed a bit in a couple of regards within the last year. Firstly, the legislature, the Florida legislature, changed their statute to provide for sort of an independent attorney general action, authorizing individuals to notify the city of people that were camping or public sleeping overnight in public right-of-way, and that if the city abided by that and didn't remove them, people within a certain amount of time, then there could be a private cause of action for damages brought against the city. In response to that, we realized we had to ensure that we had the mechanism to comply with that legislative mandate. Additionally, at the same time, the Supreme Court considered the case of Grants Pass, where they determined that previously the courts had held that it was a violation of the Eighth Amendment to the Constitution, I think it was the Eighth, cruel and unusual punishment, to sanction people, sanction including everything from moving someone from a place to citing them civilly or arresting them, obviously, if there was not a place for them to go. Sleeping would be an activity of daily living for which you could not sanction someone unless you had a place for them to go. So we were sort of between that rock and the hard place. The Supreme Court determined that that is not a violation of their constitutional rights anymore. It may very well be a defense to an action taken, whether it be a citation or an arrest, that a necessity defense that the person would say, I had no place to go, where else was I to sleep? But that we wouldn't be, ideally, we wouldn't be subject to those civil lawsuits for acting on that matter. So it all came back before the commission. There were extensive conversations, you recall, just, we're talking 9 months ago, 10 months ago, where the commission, I believe at the time, chose to just utilize the language that the legislature put in the statute. There was a concern of not wanting to go beyond the language in the legislature, but making sure that we were able to comply with the language the legislature gave us. Is that language perfect? It isn't language that I would have written, but it is language that we are that we used because it was being delivered to us by the legislature, and that's why you have the overnight camping prohibition on the public property, and it says, I think you'll find word for what the statute provides. If the city commission wants to direct us to make those regulations on camping in public areas different or more strenuous, then that's the direction that you'll give us. And whilst it may not help a bit regarding enforcement, if there are not available places, and maybe there are, that's a factual matter, I think we are at less risk, I will say, of being sued than we would have been prior to the Supreme Court's decision. But again, the determination of how far to go in this area was something that you had just decided less than a year ago.
All right, that we would just stick to the language of the legislature because we can't make it less strenuous. You can't go below the law.
You need to have the tools so that we can comply with the legislative mandate to not abide by overnight camping in the public properties.
Thank you. All right.
Thank you, Commissioner Chestnut. Commissioner Book.
Yeah, when I had looked at the revised, thank you, Mr. Mayor, the revised language for the ordinance on page 2, it did define public camping or sleeping, and yet it's probably still not that clear. Could we pull up the ordinance on page 2? And what it says is, other than the word overnight, which I won't read, lodging or residing in a temporary outdoor habitation, so that's not just taking a nap, used as a dwelling or living space, and evidenced by the erection of a tent or shelter, presence of bedding or pillows, or storage of personal belongings. So it gives us some clarification. So I'm in agreement, like with you, Commissioner Willits, and you, Commissioner Engel. I don't want somebody taking a nap for 10 minutes. They close their eyes, and all of a sudden, I don't think we would ever, I don't think our public safety would ever be probably interacting with those people. There's clear other indicators, and I think that we police in a way that's very compassionate and professional and thing. But there does seem to be some clarification in the ordinance about the public camping or sleeping, and give some behavioral indicators that help them define what sleeping is, as opposed to somebody closes their eyes, for a moment or something like that. That's just a comment as I was looking at it. Thank you, Mr. Mayor.
Thank you, Commissioner Book. Commissioner Willits.
Mr. Mayor, but Commissioner Book, on the second part of this, on the B part, it says lodging or residing. And it doesn't define what lodging or residing is, besides the fact that it's without a tent. And so again, someone who sits down on a park bench with their bag, puts their head on their bag, which could be considered a pillow, are they now, in essence, public camping or sleeping because they are lodging or residing, whatever the word residing is? I don't think that's defined. That's what I've been looking for. And that's why I personally don't want to be more restrictive than the overnight. Or if not, just define what overnight is define what it is, whether it's a time, whether it's dusk. I'm sure people don't prefer to have dusk because then we're consulting, astronomical calendars, and it changes every day. I'm sure we do that for parks so that there's a little wiggle room, but people understand, hey, when it gets dark, we're done here. So I still don't like the idea of merely striking overnight. I think it'd be better to define it, partially because, I don't know, unless it's defined here for me, I don't know what residing means. And I'll tell you, as someone with back problems, I have been known to bring a pillow with me, pull it out of my car, It's usually for my lower back. Has some back problems, but the idea of someone out in public, but also for people who are homeless, merely being able to lay their head down and sleep. And if it's a safe place, obviously we don't want them to sleep in an unsafe place. I have issues with this. Thank you, Mr. Mayor.
All right, thank you, Commissioner Willets. So this is ultimately becomes the responsibility of the Gainesville Police Department to oversee on our behalf whatever we write into code. So I'm going to invite Chief Moya to come give us his thoughts on this. Welcome, Chief.
Good afternoon, Mr. Mayor, Commissioners. Yeah, this is ultimately very, very touchy for us as well. But I can tell you where we are often, as an agency, stuck is if you look at the wording, it says public camping or sleeping. It doesn't necessarily speak of someone taking a nap, which we are very cognizant of because we come across folks that are napping, and napping is not unlawful. We all should nap. Where it becomes an issue for us is what...
Right now, because it's not a bad idea.
What becomes an issue for us, sir, is when we are in the presence of a person in a public space with all the other things that are highlighted here. Their tent, whether an erected tent or not, or personal belongings, sleeping material, where you are now, in essence, lounging or camping. So it's more of an extended stay. And we field those calls routinely. And our folks are having to navigate the kind of tough language that we see, the obscurity that we see in sleeping or camping and overnight. And what does that mean? Currently, we use 10 p.m. to 8 a.m. And so we would like some clear direction so I can give staff direction on what to do in those moments. Because those moments are technically encompassed in this, but then we're forced then to move people along because, they're sitting with their belongings, oftentimes piled up, oftentimes in a public space, oftentimes in a right-of-way. And that's where it becomes very, very tricky for us. And the kind of direction we're looking for is one that does not leave such a gap so that discretion can be applied way left to way right. We're looking to come to the middle with something that gives us some clear direction.
Okay, thank you, Chief. So I would, as an example and a question, if someone has a couple chairs and some semi-permanent structures set up in an 8-foot median and is there for hours, how do we handle that? What do we do? Is there anything we do?
Well, it doesn't forego an engagement, meaning a consensual encounter where we can just go and talk to people, either to check to see if they're okay, if they're in need of services, whether they're in a violation of our current median ordinance.
So I'm talking about bigger than a 6-foot.
Correct.
Because we have quite a few of those.
Right, and our officers will go out and make that assessment quickly. But then we fall into this discussion, meaning what does that mean? The presence of bedding, pillows, personal belongings, to how many? What does it constitute us saying, okay, this person is public camping? Not sleeping, but look, it says or, it doesn't say and. So does that mean that at that moment, based on the officer's discretion, he or she says, okay, technically you're camping in a public space, you gotta go. And because it's overnight, currently we're faced with that all the time. And in the daytime, which we get calls, copious daytime calls, we're literally stuck. And then we have property rights owners that are saying, get folks to move along. They try to cite the statute to us, which we know. We fall back to, look, it speaks of overnight. And that's where it gets tricky for us.
Okay. All right, thank you, Chief. Anyone else have questions for the Chief or Commissioner Willets?
Mr. Mayor, so knowing what state law is about that private individuals can alert the city and then further their complaint if we are not upholding state law and our ordinance. But state law says overnight, our current ordinance says overnight. by getting rid of overnight, doesn't that just actually just open the city up to even more complaints the rest of the day? I know it may be unclear about overnight. That's why I suggest putting some real times on it. But doesn't it just then open up 24/7? You know, that the public can ask us, can have even more reason to get GPD to enforce and to clear homeless people away. So I want to make sure our argument is sound here, and it sounds like we are arguing around rather than we're finding any last reason just to get rid of homeless people. I'm sorry, I'm getting a little emotional about this, but one of the reasons I don't want to take overnight out is because then it is 24/7 that you have to enforce, because it's our ordinance, and people will complain whether that's the state law or not. They're gonna cite our ordinance when they go complain to the state. So why not just keep the state's language to limit, not the limit's the wrong word, to line up what the public and private individuals have a right. I don't know if the word is complaint is the right thing, but start that process.
So despite this language being somewhat vague, at least it gives us some direction in terms of overnight. Now, because we face daytime complaints, the decision we all have to make is, there's nothing simple about this decision. It's whether we are okay in a public space for folks to set up what could be classified as camping based on the aforementioned variables, and us not do anything about it, which I'm okay with. I just need that clear direction, because the expectation that is put upon us is that we actually absolutely move people along during the day that are camping, as defined in that paragraph.
All right, thank you, Chief Mayor. Thank you, Mr. Mayor.
Thank you, Commissioner Willis. Commissioner Eastman.
Thank you. Thank you, Mr. Mayor. So just so I'm clear, because you mentioned offhand that you guys currently do have your staff, they have definition for overnight. You said it was 10 p.m. to 8 a.m.
That's correct.
So if I call and I say, and it's 11 p.m. and there is someone sleeping in front of my building, you can utilize this to enforce that. That person can be moved along.
Well, in your example, that would be if it's in public right of way or
Right.
public space. If it's a building, curtilage thereof, it may be private property. But yeah, we would have to go assess that, and yeah, technically under that definition, we would be able to ask those people to move.
So that person would then, because before there was something about overnight meaning that you might have to go and then verify that it is still overnight. But what you're saying is you can see one instance, you can ask that person to move at that time period because it is past 10 p.m. to 8 a.m. Right?
That is correct.
Okay. I mean, one of the things with all of this, and you said that this wasn't simple, I'll say that, I think all of us get calls about, so there's homeless folks that are in this park. One of the things I find with all this stuff, when you're trying to define what you're trying to stop or get rid of, a lot of times it's just people in a park, right? Like it's, this is really clear. It's lodging or residing in a temporary outdoor habitation used as a dwelling or living space. A lot of what I hear from folks who want to make sure that there's folks not in a park or things like that is harder to define than what people give it credit for. That you might on a gut level say, oh, these are homeless folks in a park, but really they're people in a park with a lot of belongings on them. And it's, I don't know if removal of overnight really, it gets us to where we want to be, particularly if what you're saying is that you guys do have a definition that you can utilize that seems, at least within that narrow scope of what you're looking at, you are able to effectively administer and move folks through to stay compliant with the law. We passed this about, I want to say it was less than a year ago. I'm comfortable just, seeing if there's some way, just continuing forward with this, and then seeing if there's some way that we could come back around and have a conversation once we have, once we have this under our belt and look at other cities. I like Commissioner Chestnut's idea. That's what I do every time I'm bringing anything to the city commission or bringing something forward, is saying, how have other cities interpreted this? What are they bringing forward? Have people who've done this better than us that we can just steal their ideas and put it into there? Because this is a very odd definition. I hear that from GPD and from everyone else. We want to make, but it is what the definition is. And I see Mr. Persons come up.
Mr. Persons.
Thank you, Mr. Mayor. I did want to clarify maybe a few points. As you all know, the Code of Ordinance already sets park hours. And so whether you're sleeping, whether you're playing bocce ball, whatever you're doing, once the park is closed, that's against the law already. And that is enforced by GPD when we do get calls about people being in parks after hours. So I do want to clarify that with public property. I guess what most of the discussion, I think, from the commission seems to be focused on the public property on the park side. I don't know, and this would probably be something for the attorney to need to weigh in, if the commission could differentiate public right-of-way camping versus sleeping like in a park, for instance, like during the day. That may be something that most of the complaints or a fair amount of the complaints that we get are for people who are actually camping on public right-of-way, like in the sidewalk or in other areas where people are, which are intended for people to move back and forth, not necessarily in a stationary type of setup that's contemplated here with the camping. So that would probably be. I did want to make that clarification.
Okay, thank you, Mr. Persons. Did you have anything else to add? Commissioner Book?
Yeah, thank you, Mr. Mayor. What Mr. Persons, what you were just talking about was exactly where I was thinking is the second section under what we're discussing here is pedestrians prohibited in traffic separators, and what you were talking about, Commissioner Eastman, that's really probably the primary issue. And I could be corrected, but Grace Marketplace experts and our houseless experts will tell us that most of the people on the pedestrian, the medians and the intersections, they may be panhandling, they're not houseless. And how do we know that? Because they contact them on a regular basis. We have all kinds of services that are provided to try and get them into housing. We have interim, emergency, exigent, and then we have with our county colleagues, we have transitional housing. So we do a lot of things to try and get them, maybe if they were houseless, from wherever they are in their vulnerable states to a state of stability. That is not our pedestrians who are panhandling at the intersections. And so I feel like we're very solid on the second part of this public right-of-way ordinance update, and probably the one where I'm guessing that we would have the majority of our concerns related to those, and that's just chapter 26. I know I'd be completely comfortable with the chapter 26 section, and perhaps like what Commissioner Chestnut, what you said, we need a little more best practice and research and review to flesh out some language that tells us specifically the additional behaviors that we want to make sure also cannot impact our parks negatively. Thank you, Mr. Mayor.
All right, thank you, Commissioner Book. Is there any public comment on this, Madam Clerk?
Mr. Mayor, no, we do not have any comment.
Okay. So it probably would be appropriate for us to give direction to staff, and I would say broadly staff, not just the attorney's office, not just the manager's office, but staff, to see what other cities have come across with this. I don't want us to be, personally, I don't want us to be out there on a limb with the only city trying to solve this. I'm sure we're not. But somebody else has language that may have already been tested and maybe not. But it would be great if we could find language that has been tested that is within the current statute and use something that's already been successful and that is humane and decent. And that is that's narrow. That's hard to find. But I would prefer that we end up in that direction. Is there anything else you want to refer to on this specifically, Mr. Mann?
No, I was going to wait till you finished on this conversation, and I was
Gotcha.
setting up to move to the next half.
All right, Commissioner Willits.
Thank you. My last thing on this previous conversation is I want to make sure we're not making assumptions that are not backed up by fact. And sometimes we may need to hear a little more from GPD, not right now, but in the future, about where are these, because I hear the word concerns, whose concerns? Is it concerns of the community that are voiced that are merely kind of complaints to GPD, or concerns versus the actual legal challenges per state statute to the city? And so I want to know, because what I see from when I drive is I do see people with a shopping cart at let's say an RTS bench, and they've got the shopping cart next to them, and they're leaning against their cart sleeping. they're sleeping. They're in the public right of way. They are sleeping. So I don't know that it's just people in the medians and the traffic separators. I want to make sure we actually have that data. We're not making assumptions about where the complaints are. We hear anecdotally complaints, but I would like a little more information from GPD in the future about where are the real complaints? Where are we seeing this the most? Where is it that we're not having easy solutions? If it's downtown and we're encountering people and ambassadors are quickly kind of helping people get to resources, I feel like we're making, even me, are making assumptions based on our own experience, and we probably need a little more data or just really wise guidance from GPD to tell us, or also GFR, where these things potentially are happening so that we understand. That's all I got on this. I know we're going to continue the conversation. Thank you, Mr. Mayor.
Thank you, Commissioner Willets. So yeah, let's go ahead and move on to whatever's next, and maybe we can revisit this.
So, Mr. Mayor, just a closing point on that for the rest of the commission, because I know I work with you on this a lot. One of my special projects that I work with in the city manager's office is coordination of all of the city's homeless services. I coordinate with GPD, GFR, code enforcement. I serve on the continuum of care. And so I coordinate all of our responses, all of the complaints we get. I work with the various staff depending on where it comes from. So that was part of the reason that we were bringing this forward, is based on the overall concerns that staff has seen. Onto the next item is the median issue. And we're looking at this as a Vision Zero issue, a pedestrian safety issue. GPD pulled some statistics, and of our pedestrian fatalities from 2022 to 2024, we had 16 pedestrian fatalities in that time, and you can see most of them, the majority of them were in a median where there was no crosswalk. And so what we've been looking at with this is, how do we improve the safety of our medians? And we already have an ordinance on the books that prohibits pedestrians from being in the median if the median is 6 feet or less. And the ordinance says no person shall stand, sit, walk upon, or stay for any purpose within any public right-of-way median that is less than 6 feet in width. And what GPD has experienced is that the people who are getting hit on the median, the injuries and fatalities we're having in medians are irrelevant of the width of the median. And so for our Vision Zero program, the recommendation is to prohibit people from being in the median unless there's a specific purpose, such as that they're in a crosswalk or a sidewalk that's in the median or some other type of pedestrian area.
So, Mr. Mann, I don't remember, because it's been a few years now. How did we arrive at 6 feet? What was our?
I did not work on that. I don't know if Major Koenig worked on that or not. The 6 feet?
If I may, Mr. Mayor, I remember this is another of these situations where everything old is new again. This is an issue that comes up periodically over the years, and I think most recently, probably about 5 years ago or so. And at the time, there was, and I don't know if we've had the chance to refresh the research. At the time, I think that there was significant case law showing that roads in this country are often traditional public fora for which speech and speech activities, and bear in mind, First Amendment speech includes not just your political, vote for so-and-so, but it includes activities such as soliciting and panhandling and political speech, vote for so-and-so, or here's a car wash down the street, things such as that. But that roads have been traditionally a traditional public fora, and that they cannot be infringed upon except for legitimate time, place, manner restrictions as narrowly tailored as possible. The case law drew I would hesitate to call it a bright line, it was sort of a gray line where cases of medians that were less than 6 feet, it was concluded, there was a greater ability in the name of public safety, traffic safety, pedestrian safety, to restrict any stopping or standing or any activities, regardless of whether they're First Amendment or not, especially regardless, from taking place in those, because they weren't designed for anything more than just dividing that traffic. They were part of the vehicular traffic. And that same sort of gray line would imply that medians larger than that size, that those safety concerns wouldn't outweigh the potential infringement upon First Amendment activities. That's where we sort of landed in an effort to comply with the law. And whether or not there's been change in the jurisprudence, change in the case law between then and now, that would lead us to believe that we might be more risk-free or less risk inherent to make that restriction greater, that medians of any size we could prohibit stopping and standing in. We can perform that research and then work with the police department, manager's office, whomever, to try to refresh that research, I said, and bring back recommendations.
Thank you, Mr. Attorney. So I'm pretty sure that was my motion back then. And the reason that it was 6 feet is that's what we arrived at. It wasn't, I didn't come out of the gate with research saying, 6 feet is a magic number. It was what we could do, I think.
Yeah, it was what, through looking across the nation, what was allowable in terms of regulations that we felt we could reasonably do. And also reasonably concerned that, okay, it's less likely there is going to be driver distraction and injury to the person in the median the larger it got. Whether that's a truthful, whether that proved to be correct or not, maybe we could have evidence or anecdotal talk about whether or not there have been injuries in medians.
Okay, so my concern about that continues to be, as it was then, entirely about safety. That if you fall, as people have, into traffic, you will be severely injured and potentially create a domino effect of injuries, as again we've seen happen. I understand what the rhetoric is that will surround the idea of expanding that, but I'm interested in expanding it. I don't think it is safe for people to be in medians longer than it takes to take a respite across the road. I don't. Whether that's a youth football league out there trying to raise money, or who, by the way, have gotten out of the medians for the most part, as far as I can tell, or someone doing traditional, what we call panhandling. It presents a danger, and I don't want anyone else to be hurt or killed in a median, hurt or killed because they were standing in a median and tripped. Because let's face it, they're not in the middle of the median. If it's an 8-foot median, they're not in that dead center. If they're there for a reason, probably, which means they're going over to the edge of the median. That's the reality of the situation. So I would be comfortable with expanding that, with striking the width on this. And I know that there will be rhetoric coming at me, but that's okay, because this is about keeping people safe. So I don't see any lights. Is there any public comment on this part?
There is none.
Okay, all right. Commissioner Book.
Yeah, thank you, Mr. Mayor. Is there anything, excuse me, Mr. Mann, where Section 26, if we pass that, would impact our ability to look further into Section 23?
Mr. Book, I don't know that I'm prepared to speak to that. But there's nothing that I'm aware of.
Seemed like the easy path is to pass the information related to the separators and deal with that other section separately, as we've talked about. Mr. Attorney, would there be issues if we passed Section 26 with the change impacting Ordinance Chapter 23?
Mr. Mayor, that's my point. I don't know. This hasn't come back to us for review and discussion. If the commission wishes to direct us to refresh that research, to conduct that research anew, and come back to you with either a revised ordinance in this regard or a detailed recommendation as to why it's not a good, why we think we're prohibited, then we'll do that. And we'll get that done as expeditiously as possible, also working with the police department and the manager's office, obviously.
And Mr. Mayor, just for clarity, staff's recommendation is that these proposed ordinances be referred to the city attorney's office for review and further vetting.
Okay, well, with that, I move 2024-834. We refer both of these ordinances to the city attorney and staff for review. Based on the information we've heard, bring us back the best practices incorporated in there. It appears that chapter 26 is probably largely squared away. But that would be, excuse me, that would be the motion.
Is there a second?
Second.
Okay, we have a motion and a second. Commissioner Engel.
I have certainly used the roadways as a traditional means of communication many times myself. I've walked, I don't know how many picket lines, walking down traffic, handing folks from the side of the road, handing out flyers for causes and events. Obviously, I waved the James Ingle sign on occasion. So I'm very much in favor of allowing the sides of the roads to flourish with people that are trying to communicate with folks in cars. In none of those situations did we walk the medians, did we go out in the middle of traffic, and I think that's a much more dangerous situation. I would be very much in favor of looking to get rid of that in medians and not get in arguments over whether it was a 6-foot median or 6.5-foot median and when it's safe and when it's not, because I think interacting with traffic from the middle of the road is a pretty dangerous place to be. I'm a lot more skeptical on the first discussion we had, but if we're looking at referring these to the city attorney so we can get some clarification on exactly what we're looking for, I'm happy to vote for that motion and kind of get those differences hammered out as we go forward.
Thank you, Commissioner Engel. Commissioner Eastman.
Thank you. Do we know how many, and I know that we're just referring this for review, but do we know how many over 6 foot? First of all, what is the definition of a median that we have in our ordinances? Let's start there, because I think we have an idea of what a median is, but what is a median?
So, Mr. Mayor, a median would be any part of the roadway between opposing travel lanes or even between parallel travel lanes that is separated and not used for traffic. It can be a raised median, such as a concrete median. It can be a flat painted median, like some of our medians on Northeast 39th Avenue. It can be, grassed, raised, concrete, or paved, marked out.
Would a pedestrian island, would that be a median per se?
A pedestrian island could be a median, but it is covered under this as a place pedestrians are supposed to be.
Okay.
Are allowed to be.
So when it says no person shall walk upon a public right-of-way median, there's some carve-out for things designed specifically within, except areas that are specifically designed for pedestrian access. Okay. So this wouldn't, I guess that goes into my second question of Northeast Boulevard has, the duck pond, or that area right in between that. That could be theoretically designated and marked for pedestrian access, in some way, pedestrian sign, you put up some kind of pedestrian sign.
It could be designated a park, yes.
Okay. Okay, so there is some way to ensure that, that this doesn't accidentally entrap things that we don't mean for it to do. Do we know how many above 6 foot wide medians we have in the city of Gainesville? Is this common to have? And most of the medians I think of, when I am going on Newberry, there's these little medians, and I will see people kind of walking along those, and I get spooked by it.
So we have, in recent years, we've built a lot of 6 feet or less medians, but we do have a lot of roads that have wide medians on them. The best example that comes to my mind is 39th Avenue from the West City Limits line to Main Street, or actually all the way to Ironwood Golf Course.
Yeah, those are large.
University Avenue, East University Avenue has some medians that meet that criteria. Waldo Road does.
Yeah.
Archer Road.
Clark Butler Boulevard.
Yeah. Okay, so there are some real places that this could be used, and then I guess there is some protection there. So I guess I'm not uncomfortable with it. I think it makes some sense. I am still not sure about the very first ordinance that we're directing over there. I don't know what well, for all the reasons that I mentioned from before, that I'm not sure what it solves in terms of the overnight section, because there's still very tight language outside of that, and I'm not sure I'm comfortable with expanding that out too much further along than what we have within state law. State law directed that to it. We passed this less than a year before. I think letting that thing play out, and I guess I can. I'm happy to kick this over to the city attorney's office and city staff in general to just take a look at and see where they are for the second portion of this. So that's what I was going. Thank you.
Thank you, Commissioner Eastman. So we've already covered public comment, and I see no further lights. All in favor, please say aye. Aye. Any opposed?
Nay.
All right, so that's 2 nays, is that correct? Okay, all right. So that,
Three. You did. Okay.
okay. That passes 5-2 with Commissioners Willits and Eastman and dissent. Is that accurate?
Yep.
Okay. One of these days we're going to get a light system where I know exactly what moved in what. One of these days. Okay. All right. Thank you, everyone, for that one. Commissioner Duncan Walker, I'm sorry.
Thank you, Mr. Mayor. As we were sitting here deliberating and having this conversation, particularly about the definition of overnight and how we would arrive at that, I don't think there was one of us up here who wasn't terribly uncomfortable. And one of the things that occurred to me was, for me, I would like to bring the community into this conversation about, how we arrive at what needs to happen. Because ultimately, I think they're going to be not just many of the people who are, quote, impacted, but I think about the advocates for those who are unhoused and how I don't see any of them in our chamber today. And I would love it if we would intentionally make them a part of this decision-making process. Because right now, our hands are tied as decision makers. But to bring them into this process in a very real, meaning, and intentional way, that helps us to probably arrive at the best solution underneath the parameters that we have to operate, but also the education piece that will have to happen once we do arrive at that definition. I really want to bring them in a meaningful way. So I would like for staff, if we can, to include them in this conversation. They should not be left out of this. I just wanted to make sure that I made that statement because they're going to be some of the people who we will have to rely on to make sure that as best we can, we are going to be able to minimize the harmful impacts on our houseless neighbors. So thank you very much. I certainly hope staff has been able to hear me and that we'll be able to bring in those advocates. I certainly know a lot of them personally and I'm happy to give names, but let's please bring them into this process. Thank you.
Thank you, Commissioner Duncan Walker. Commissioner Eastman.
I think that's a great point, Commissioner Duncan Walker. I think similarly, so I think before we get the ordinance back, I do think that it makes sense to engage with some of the stakeholders. So I would like to make a motion that we direct staff to engage with the community to determine the impact to stakeholders and return to the commission with that information when that comes forward.
We have a motion, a second. Any further questions about that, comments? All right, all in favor, please say aye. Aye. Any opposed? All right, that passed unanimously. Before we move on, I just, so Mr. Persons, I heard you talking about bocce. I'm a little worried about, roving bands of midnight bocce players. So I'm not, I'm just entirely joking. So, sorry. Madam Clerk.
Mr. Mayor, we're on to 2025-779, the presentation on the RTS ADA Paratransit service. With recommendation, the General Policy Committee receive the presentation on the plan to insource the regional transit system's ADA paratransit services.
Welcome, Mr. Persons.
Thank you, Mr. Mayor. I did want to recognize that we have a lot of RTS staff here to help answer any questions. If you recall, I believe the last time we were talking about paratransit services, there had been a referral to staff to come back and have a discussion to really kind of talk about the transition plan and to try to answer any questions that we can as we move forward now that the budget's been approved. So we have a brief presentation and then we can kind of get into as much details as you'd like. We're going to cover a few topics with this presentation, starting with what is paratransit service. It is a door-to-door service where we pick up folks and bring them within the fixed route service area. I have a map which will show you. This is the red line you can see here. It's 3/4 mile outside of our current fixed route transit. That is what we are by law required to provide paratransit services. Those trips have to start and begin and end within that service area. They can't go out of that area. That's a separate program. Let's see what else to talk about here. I think it covered that. Paratransit service is reserved a day in advance. If you recall, we've had a number of discussions regarding that reservation framework, and that is both people picking up the phone, and then as we move forward in-housing paratransit, that will be a service that's provided in part through our VIA software, which is the same software that the city currently uses for our mobility on demand service. So we'll be working through that as we go forward. That's the service area. As the commission knows, a lot of the discussion has been really focused on the cost of ADA paratransit services and the contract that we have with MV. We project that MV contract would be increasing as up to $3.2 million. After staff had done a significant amount of analysis, we believe and continue to believe that we can bring that in-house for a much less expensive cost of around $2.7 million. I can get into a lot of the detail in terms of how the MV contract has increased over time, even though the ridership levels have largely not increased as much as doubling the per trip average cost over time with the contract. But all of that is in your backup for this agenda item, and we'll kind of take the commission's lead in terms of how much detail we want to get into that. We in addition to some of these financial considerations, as the commission knows, we provide 17 of the paratransit vans to MV for their use. Those vans, it's important to note, not only provide paratransit services within the service areas you saw, but those vans are also used outside of the city limits. They're taken to use for the transit disadvantage, the TD program. So they're all over the county. As we bring those in-house, those vans will come back to us, and then we have additional vans to supplement the paratransit service going forward.
Hold on just a second. Commissioner Chestnut.
Thank you, Mr. Mayor. The 17 vans, are they leased
No.
to MV? Do they pay anything to us for the use of them?
I don't believe so. They're city vans. I'm getting a lot of head shakes, so no, they are not.
Do we service the vans?
Generally, MV services those vans. We do periodic checks for compliance for I believe FDOT standards, but they do the service on the vans. We, as you all know, we have have made significant investments in the federal level to have a full service maintenance facility that we believe is in part how we're going to realize a lot of the cost savings, both from the operations with the admin building as well as the service fleet and service facility that we have here.
Thank you.
Thank you, Mr. Persons.
Let's see. So our estimated timeline, now that the budget has been approved, we have a paratransit job description that we are going to be recruiting for. That is, it's important to note that we will be providing opportunities for any drivers that are currently providing fixed route service, first opportunity to move to a paratransit operator position. We have also been in contact with a lot of the MV drivers, and I believe we are competitive in terms of salary and benefits with those drivers. So that would be our first choice in terms of bringing over existing MV drivers. We've already been working with HR, and we have an expedited process by which we can hire those drivers to help reduce the recruitment time. We are continuing to implement the VIA software. We're beginning training for staff. Again, I've got more details than you probably really want on this, but we're happy to get into as much detail as the commission desires. But we are continuing to implement the VIA software, which will be our primary routing software for the paratransit once we in-house. We are anticipating giving notice to MV probably later in November, and we are going to be continuing to onboard new employees and to conduct training. We have developed a paratransit training program that we've already reviewed and gotten approval from FDOT, who has to bless that. So we have a program already approved, ready to go for training. We are continuing to, we'll be continuing to work with Center for Independent Living, which already provides services in both in training riders in how to order and to schedule paratransit service, as well as doing some of the screening for eligibility. We'll continue to be working with communications and pushing information out as the city does branding with the new service, the paratransit service, contacting agencies, riders, that kind of thing. And then we will be providing additional training. I think as we sit here today, we anticipate being able to go live really kind of in that original January time period. However, it is important to note that we are not going to go live until we're ready to be able to give proper notice both to riders as well as to MV. So we want to make sure that there's some flexibility. So we're looking at March as a extended time period. That's going to be dependent on recruitment and whatnot, but we are still anticipating being ready to go by the end of the calendar year. But we're not going to pull the trigger, if you will, anytime earlier than when we're ready to do it, because obviously the transition is going to be very important to make sure it's smooth and seamless, and that we're continuing to provide excellent paratransit service to our vulnerable riders. One piece of, I think, discussion that's been occurring is the other portion of the CTC responsibility. As you all know, MV is a for-profit company. Their last, I think, disclosures, they made about $800,000 worth of profit over the overall services they provide as the CTC coordinator. They are the only for-profit provider or CTC in the state. And there's been a great deal of discussion, I think, both at the city, county, MTPO level about the assumption of what happens once the city assumes paratransit, which again is the bulk of the trips that are provided. We have done the analysis, as you can see here, about how RTS could assume those CTC responsibilities, where our gap is in terms of staffing, vehicles, and then we would have to update contracts. I do want to say that we are committed to continuing dialogue with the county, working through these issues. I know it's a sensitive issue on the county side, and obviously I think the commission has expressed in the past about the desire to continue to try to work towards a solution that doesn't leave anyone in terms of riders in the lurch. So we are anticipating that at some point the RTS will take over CTC responsibilities. However, that's going to be a separate discussion at the MTPO level. I just want to say from our perspective, we are committed to continuing that discussion and trying to ease that change. And with that, that concludes the presentation. And as I said, I and RTS staff are here to answer any questions in more detail as you need.
Very good. Thank you, Mr. Persons. Let me say before we get started that I have tremendous faith that both the current system with MV and the future system with RTS will provide, has provided, and will provide excellent service to the people being served. That's a commitment. That is a legal commitment from us. We have to do that. That's not something we can just forget about doing. So that is at the forefront of our minds as we move forward with this. And I thought that went without saying. That's my mistake, because we've now been called into question about that. And I take that personally. On behalf of the drivers at our transit system, I take that personally. I believe that we can provide at least as good a service through good union drivers at RTS in the city of Gainesville as can be provided through a for-profit company. There's nothing wrong with being a for-profit company that offers services. They've done a fine job. But we're at a crossing point now, and I would hope that there would be no concern about whether or not our good union drivers can continue to offer the same service that they have offered thousands and thousands of people every day for many, many years. This is a little different service. We're taking the training very seriously, as you see here. And of course, we will continue to take that seriously. But as I've seen this conversation be in the public, moved in a particular way, very intentionally, somebody needs to stand up for our drivers, and that's me. So we'll move on with that. Go ahead.
Mr. Mayor, if I will, if I may, one thing I think that I did want to touch on is the letter from MV that we received with the proposal to reduce their costs. We did meet with MV Monday of this week to talk about that. The proposal, as you see, is proposing to reduce the annual cost by approximately $500,000, which would be in line with what the city's estimated cost for in-housing the services. There are some, I would say, information gaps in terms of what the cost per trip would be, what the rates would be. It is really important to note, and I don't think this has really kind of been in the discussion, but it was in the discussion on Monday, that in order to realize those savings, MV would be significantly changing the service model from how we currently operate with the contract by providing paratransit trips with the vans that you see around the community with full-time MV drivers. Those drivers would be replaced by a TNC model or a transportation network model, which is similar to Uber and Lyft. So those trips that are currently being provided in those paratransit vans that you see would be replaced by 1099 contracted drivers who would be operating as if, in akin to an Uber or Lyft model. I don't think that's been discussed because I think it's been conveyed or implied that somehow it's a one-for-one type of reduction, but that reduction of cost comes with a significant change to the service model that MV would be providing. And so I think it is important to note that. It is also important to note that the city in-housing would not change that model. We would continue to provide the same type of paratransit van model with an enhancement to how those service calls are made via the software improvements that we're going to be implementing.
And to be clear, you're not asking us to make decisions today. This is
just purely informational. Yes.
Very good. All right. Thank you, Commissioner Willens.
So I understand about what is the real difference between paratransit and the TD, the types of trips or where they're going? I know obviously TD is countywide, correct?
That's correct, and I probably will have staff come up and help who are a little bit more familiar. I can answer some of the questions, but in case you want to get deep into the TD discussion,
this is going to lead to, I just don't understand why it is, 45% more expensive to provide a RTS funded paratransit ride than a otherwise funded transportation disadvantaged.
Right. Well, a few things to note on that. The TD trips tend to be longer because they're obviously out into the unincorporated area, not within the city. Our paratransit service area, as you saw, is more compact. So all of those things should lead to the conclusion that those trips, the paratransit trips, should be less expensive. However, if you look at the rate that that the city pays for ambulatory trips,
Excuse me, I was specifically talking about
yes,
ambulatory,
yeah, ambulatory
not,
trip,
not the full wheelchair
right.
lift, all that.
Right. If you look at some of the wheelchair trips, the rates are generally about consistent with the other programs, TD. But if you're looking at paratransit and ambulatory trips, our rate is, roughly speaking, about $20 more expensive per trip. Even though the service area is smaller in terms of where those trips originate and end, and the bulk of the trips are in that category, so we're not getting a bulk discount in that sense either. Why that is largely, I think, comes down to that's essentially what the contract is that we have with NV. That differential. I don't think that there's not a service difference. It should be less expensive, or at least on par with those other programs, but it's not.
But TD could be for people who are not necessarily needing paratransit. It's not about a disability necessarily. It could also just be people who can otherwise not afford transportation.
That's my understanding. I believe that I'm getting agreements there.
All right, I'm trying to just kind of wrap those things. Thank you, Ms. Persons. Thank you, Mr. Mayor.
Thank you, Commissioner Willets. Commissioner Eastman.
Thank you, Mr. President. I agree with the mayor that I have full faith in RTS to be able to pick this up. We do, as you, I think you mentioned, we do ADA service on our fixed routes. There's some learning that we'll have to go in to do, this type of work. But I think, I have full faith that our staff is up to the task, that they'll be able to provide really good service. Has there been any, to start with that, during the transition, since we're beginning that, has there been any outreach to the customers, or plan to do outreach to the folks that use the current paratransit system to, collect feedback like we would normally do for any kind of program change like this?
I'm going to defer to Mr. Idioga or Mr. Gomez on that one.
Welcome, Mr. Gomez.
Mr. Mayor, Commissioner Jesus Gomez, the Transportation Department. Yes, we have been in constant communication, and we have also talked to the CAL, so to start letting people know how that's going to change. Of course, we went into the final budget decision was safe to continue doing more. We have the list of all the ADA eligible people in the city. We're going to be providing information to them, to the personal care attendants, that actually the ones who book the trips for them, and all the agencies that are involved on these services, elder care, the senior center, hospitals, and social services.
Right.
We have we have a lot of marketing materials again that we are working on already updated. One is the ADA Paratransit guide. That's we updated to be the information that we're gonna be sending out. Because we're gonna have internal newsletter that people can also get into our website and get the information out. Our website is completely ADA compliant. We did a new website to do that. Let me see what else we have. Oh, branding. So the new branding for this service is gonna be RTS Plus. So you're gonna see the vans with a big RTS Plus. So that will be the ADA service that we'll be covering. So, but Tom is here. He's the one doing all the marketing and the information out. But that's we're gonna do a lot to job fairs coming soon to recruit the drivers. So we have a lot of, already, let's say that on the back end information, just waiting for the budget to be approved yesterday. So we're going to be up and running soon.
Yeah, that looks great. I think, yeah, I mean, I'm glad you guys have put so much thought into it. This looks great, Tom. You know, I've seen this in other areas where they'll have the main bus system or the train system, and then they'll have their ADA or their kind of smaller rides branded in a different way. And I thought that was a savvy way to do it, so people know that that's not the official bus. And that looks good. That looks sharp. But one of the things that I want is we were getting. Folks were reaching out to us that were part of the disability community, and they were talking about MV. There was what I heard from them was to some extent, fear of that what we currently have is, of course, not perfect, but it's good. We know our driver, we know how this works, and that they've been doing this for so long that just fear that during the transition, that maybe some of those smaller nuances, and I don't know all of the nuances for all of this, might get lost in that. I'm sure we'd pick it up at some point. But is there any? I hear the communication to people about this change, but is there any feedback or things that people like about the current system that they would like to see transferred over? Just best practices that is from the Paratransit that we'd be able to pick up when we pick this up as well.
We definitely have some of that. There when you're used to have the same person transporting you all over the place, that you have that. But that's why we have the training. We're gonna be doing a lot of training, and on the fixed route, like you said, we have that. We carry 600,000 passengers a year on, and they know they're being trained how to deal with people with disabilities.
No, for sure. And you guys do a great job of that. I guess what I'm saying is that it would be like some kind of more formalized process that reaches out, because we do have the list of all the folks that are on that, like to just so that we are prepared to be able to pick up on those nuances more quickly as we're doing this transition. I think would be helpful.
That's what we work with the Center for Independent Living.
Great.
They're doing training for us, so we're gonna be involved in there a lot more now.
Okay.
And with that newsletter, we're gonna be kicking out one October, one in December. We have the mailing list of the existing clients, so they can see what's going on, and they're prepping. How to ride the bus, who's eligible, all that will be out there. So we're gonna have 2 this year, 1 at the beginning of next year, and then we're gonna go 3 times a year like our other Department of Transportation or Citizen Zero newsletters.
Great. That's great. Well, thank you. But then, I appreciate all the work you guys have put into it. And I do think this is that we'll be able to pick this service over and it will be fairly seamless. The one thing that I've been concerned about this for a while, and this goes back more to the, I'm not entirely sure what we do, how this contract transitions with that 15% of folks that are outside of city limits. It's about 15%, right, that are within the county area. And then there's about a year, maybe less than a year, because we're talking March to October now, if I heard you guys right. What does that? How do we make sure that we're not? I know it's not our jurisdiction, but what are the plans with us working with the county and the rest of that CTC type work, so that we're not dropping that and that gets picked up? And that could be to Jesus. I see Jeff Hayes is in the room here today. I'd like to hear from him at some point, but anyone who'd like to answer.
We've been in constant communication on that area. Our goal is to be ready, but that will be, I guess, depends on your direction to the city manager on it.
Yeah.
But we'll be prepared.
All right.
That's where I have my staff here. He's committed to continue to do a good job, and we'll be ready to go. You tell us to be ready to go, we'll be ready to go.
Ready to go, you mean
on March to be in the CTC? That's what you want to push us to do.
Is that even a possibility that you could be the CTC on March 1st?
Well, our preference is October, because we did give us some time to see how the AD service is going, and then assess that to be ready in October to assume the CTC.
Mr. Mayor, if I might intercede just for a sec, because we've had some significant discussions about this, and based on my understanding, we would not be ready to proceed with expanded service beyond what is in Gainesville between that January-March timeframe in 26 that we've been talking about. And so I just want to be careful, because there is a lot riding on that gap in terms of how it's filled.
Right.
And based on what you're saying, Jesus, if the commission tells you to be ready in January to March, you'll do that, and I'm just not sure that is operationally possible. So I need you to lean in a little bit more on that.
Yeah, well, because if you say that if we hear from the county and they say, we don't know what we're gonna do between March and then I say, well, great, we have the solution, Jesus says we can do it, but then can't do
Well-
it, then these are all the things we gotta weigh out with this, right?
Yeah, and you don't know what NV stake is gonna be, if the NV is gonna stay for the transition or not. So that's something that we're trying to be ready as much as we can. I know, like the city manager said, in May will be, March will be okay with the ADA service. But, if we have to assume that, it's gonna be a tough transition. Because we'll be ready in October for the CTC, not a.
So we're gonna do what we're gonna do here, I know, but let's be careful to not negotiate contracts until we need to negotiate contracts. And we're gonna have a conversation about this at MTPO in just a couple of weeks. So let's.
I hear you, Mr. Mayor, but I just want to make it clear from me to our staff and to anyone else that, I do think this is something that we do need to take seriously, and it's something that I want to make sure that we, that we're working with with the folks that are also under the contract. I know different jurisdictions, different areas, but I would like to find solutions there if that's at all possible. And then I can follow up with more questions later, and hear from my other commissioners. Thank you, Mr. Mayor.
Very good. Thank you, Commissioner. Commissioner Engel.
Hey, few questions. One, so this is new software going forward, from what it is, for Paratransit, for what they're using now. Are we comfortable with these clients that often are gonna struggle with new apps or new software, are gonna be able to work with this new system in time for that changeover?
Yes. We currently use it for mobility on demand service.
Sure. Well, and I know we've got experience with it. I just know that the customer is not necessarily going to have experience with it, and we feel like there's enough of a transition period there to make that work.
Yes, and the difference is you're gonna be able to pay fares through the app too. You don't have that now with NB.
Very good. One of the things I've heard a lot from NV is how much training their people get. Mm-hmm. Roughly how much training are we looking at when we're talking about getting people ready to take over this paratransit service?
We have a program of 3 to 4 weeks.
Okay.
But if the driver is already trained on, RTS driver or NV driver, they probably take 2 weeks to go through the training.
Okay, so we're looking at 4 weeks, so roughly 150, 160 hours of training to get up?
Yes.
All right. And then just in general, to go from somebody we've hired in to a driver, about how much training does that take in general? And not for paratransit, I mean generally for our fixed route drivers.
Yeah, the fixed route is 4 to 8 weeks
Okay.
because they require a CDL driver's license. We don't have that with the NV vans. They don't require CDL, so
Sure.
that's what it's for, 3 to 4 weeks.
So any of our drivers that would be moving over to paratransit will have already had a couple of months worth of training just in transit in general, plus
Yeah.
whatever experience they've had on the road, plus an additional 4 weeks of training before they step into paratransit.
I would say 2 weeks because they already
But
been
if they
trained.
already
Yeah.
got the CDL part of it. All right. Very good. And then I think you've answered most of my questions. As far as the transition over, have we been able to talk to NV as far as with the training to where maybe our people would be doing some ride-alongs or anything like that towards the end of their contract so they get some firsthand experience of how that's actually working now?
That's the next step to talk to the NV.
If I might intervene, and Mr. Persons may want to actually supplement what I'm saying. When we met with the MV representatives on Monday, and even a meeting prior to that, there was some conversation about the city utilizing or continuing to partner with MV to actually kind of help with the transition. And so I'm assuming that is still available, but we did talk about that. And the other thing that I think is important for us to talk about is it's not a one-to-one transfer in terms of, one of the drivers on our regular routes right into an MV role. It takes a different temperament, if you will, and just a different level of concern, if you will, for the folk who are doing for our clients on that. And so that is another reason that we have to be cautious about whether we can fill that gap in terms of the services that the city provides and then those additional services, because the employees required, I don't know that we would be able to train up and have enough beyond what we have necessary for the city of Gainesville services. So Andrew, you want to pick up on that?
Just to add to what the manager said, as you all know, this transition to in-house will prevent us from eliminating 30 positions, 10 filled, 20 that are drivers that would be recruiting for this service. In order to in-house the CTC component, we would have to add additional positions to RTS's budget. And then in addition to all of those other things we talked about, new contracts, discussion of the MTPO, discussion with the CTD at the state level. So there are, I don't want to sit here, I think from RTS's standpoint, they're like, they're ready. But I don't want to, there are many things that are still outside of the city's control. And so while we're committed to continuing discussions and to trying to ease, the transition, and as much as we see the RTS becoming the CTC, we want to make sure we're 100% successful with paratransit before we, take on another bite of the apple.
Very
I absolutely hear that, but I want to make sure that we're not leaving people hanging either. So however that works out, I'm looking forward to making sure that works. I guess my last question too was, I know the paratransit is, the kind of range for that is roughly based on fixed route. Is that correct? Like you're within X amount? And has that footprint changed significantly because of the route changes that we've recently had?
Didn't change much because it covers almost the same area.
Okay.
But it's 3/4 mile from the fixed route.
All right. And
But
the routes that we've cut haven't
They're the
changed
ones that,
footprint.
yeah, mainly in
Because
the
they're
middle
mainly
of the,
internal.
yeah.
Gotcha. All right. Yeah, I think that's all I've got for now. Thank you.
Very good. Thank you, Commissioner Engel. Commissioner Duncan Walker.
Thank you, Mr. Mayor, and thank you to the staff for the presentation. I'll just, because
I'm asking you to,
yes, ma'am.
the decision to do what in particular?
The decision pulling in-house, because there's a lot more conversation that.
That has occurred. The commission made that decision as a part of the budget.
Thank you very much. Okay, now, so thank you, Madam Curry. Now, let me ask the question, because that means I didn't process what was just stated clearly. Thank you very much. So I want to go back to.
Yeah.
Got you. Where is that population now receiving their services from?
All of that service is happening within the unincorporated county. None of it's
The
in the
county is
city.
now taking care of that.
Right.
They have something that's already in, separate contract already in place, and they are already doing it. With MV.
Right.
Okay, all right. When we talk about the city not, quote, being ready to expand, give me a little more clarity about what we're not exactly ready to do.
That portion where we would be running service out into the unincorporated area to serve those TD trips, and as well as some of the elder care, other types of small trips. But currently, what the commission has approved is in-housing all the paratransit. So all the area within this map, all the area in red, we will provide paratransit services within this area. The areas outside of that red area and the unincorporated area, that is part of that TD program that is with the county, and that those trips are done through MV.
Okay.
And that's the portion that we're saying that we can take over, but not until October.
Not until October.
Correct.
Okay, thank you for that. Thank you all for that clarity. I conclude.
Okay. Thank you, Commissioner Duncan Walker. I don't see any other lights, so let's go.
And so, Mr. Mayor, to the commission, one of the opportunities that we see, GCRA is looking to piggyback on this contract, and they're looking and exploring opportunities with the CLT. And so instead of arriving at a new contract, what they want to do is they want to piggyback on this agreement. And so to provide additional flexibility for the CLT to service those clients that are more moderate. So it is increasing the level from 80% AMI, which is considered low income by HUD, to moderate. So it allows them some additional flexibility.
Okay. Obviously from our perspective, we want to keep, 120% AMI gets up to above the, by definition, the area median income. I know under state law that's considered low income, but we try to focus on that 80% AMI. Does this mean that all of the projects going forward would be at 120% AMI? What does this mean in terms of us working with them and the policy going forward with them?
So it provides them with greater latitude on future projects. So within the projects that we already have related to like our ARPA contract, where we provide them with $1 million. This is not the ARPA contract, but related to that. There's certain stipulations in that agreement that prohibits them from going up to 120%. Plus the property donated under this original agreement has certain stipulations within it that won't allow them to go above 80% AMI.
So does that mean?
So this is for anything in the future, not anything that we have presently in the portfolio.
So everything in the future could now be up to 120% AMI?
If not specified within the agreement. So when the city transfers land, there's certain stipulations within that purchase and sales agreement.
Right.
And you can make it more restrictive within that contract or less restrictive. What we're saying within this agreement, for them to provide services, we're allowing them that latitude to go up to 120%. And this was based on the flexibility, that it would give them the flexibility that, for instance, if they were to do something outside of the norm and provide mixed income opportunities, they would be able to do something more at a market rate type structure.
But we would still, or your staff would still have the discretion to determine when you're transferring that land, or they would have the discretion to determine?
Yes, the transfer of land isn't handled in my department, but yes, the city would still have that ability to make it more restrictive. For instance, if Community Land Trust or Bright Community Land Trust in this instance,
going up to 120% AMI is sort of the default unless it's connected to SHIP or some of these other ones, or are we saying 80% is there except for 80% is the standard except for kind of one-off, like things outside of what we typically do? Does that make sense?
Yes.
Yeah.
So if you approve this agreement, it allows them to go up to policy that has restrictions on, that has stipulations on transfer of property for affordable housing, which is set at 80%. And I think as Mr. Harris indicated, we routinely record land use restriction agreements when we transfer property. So this doesn't sort of take away the city's ability to continue to enter into those restriction agreements when we transfer property at the 80% AMI level. It just doesn't have this contract be the cap at 80%. It allows for the land trust and the city to work together on mixed income projects to provide land trust housing at 120% in those types of limited instances. But from staff's perspective, our recommendation is always going to be, because that's where we have the gap and the need at that 80% level. But it provides a little bit more flexibility for some out-of-the-box types of projects.
But you said that there's a real property policy that limits things to 80% as well.
That's correct,
So when
yes.
we are physically giving the property to the community land trust, is that a policy that would come back to us for change, or is this an administrative policy?
No, it's a commission policy.
Okay,
Yeah.
and so there is still a policy that when we have land and we are giving it to, I guess, an entity, that 80% is the standard.
Right.
This is just, okay, I think I understand now.
Yeah,
Okay.
and not to get too far ahead, but we do anticipate having some follow-up discussion with the commission on other areas now that Bright is finishing out their ARPA related lots. I think there is opportunities to continue to work with the land trust, and we want to make sure that we have all the sort of pieces in place that we can come back to the commission and have be able to present you some ideas and some options for ongoing work with them.
Which you wouldn't be able to do so long as the contract, which is for 3 years,
Correct.
caps that.
Anything we would do in that case would have to be at 80%, and would preclude any sort of mixed income opportunities or mixed housing types of projects.
Perfect. All right. I think that does answer my questions. Thank you, Mr. Persons. Thank you, Corey.
Thank you, Commissioner Eastman. Commissioner Willetts.
All right, so I want to make sure I understand this as well. It's a little hard to wrap around. So in the future, we could still, in essence, the future commission can still kind of case by case, where let's just say, and I think it's, for me, it's helpful to understand, with our ARPA dollars, we were talking like $100,000 per door subsidy, right? $1 million, 10 original, that was original idea. So that case, we're really talking about like, hey, 80% AMI, right? You know, but in the future, particularly not where we're donating land, but where there's maybe some other city subsidy, and we want to work with the community land trust for this. Let's theoretically say it's a much smaller per door. Let's say it's something like $5,000 per door of a subsidy. We could participate in that way, and if their intended buyers are up to 120%, we would make that decision then and there. And I give that example because the original CLT is very big subsidy per door for home ownership at 80% AMI, versus in the future, maybe it is a much smaller subsidy, not on land that we donate, but merely we're somehow cooperating. So am I imagining it sort of as one potential?
Yes, so you're exactly right. So with this agreement, and I had conversations with Mr. Persons in the past, really with this agreement, you're just recognizing them as a CLT because you've transferred all the land that you've said that you would transfer under this agreement. So this is just, again, recognize them as another affordable housing provider providing services of a CLT. Any funding would come before you with those restricted covenants. Like, for instance, the commission allocated $1.6 million, and those had, more restrictive income limits than what we're presenting to you today.
Right. Okay. And then just to make sure when I'm looking at this agreement and contract, where it strikes out 80% and then it says 80-120%. So just to make sure I'm reading that right, because I would assume we would completely get rid of the 80 in there and only leave the 120.
Correct. Yes, sir. So it's up to 120%.
Are we all looking at the same agreement? Is there good catch? Am I making a mistake in understanding this? Because it strikes out 80 in one place, but then underlines, which is usually addition.
Right.
It still has 80-120, as if it would only between 80 and 120. And so I want to be real clear that what we're talking about versus what is written down is the same thing.
So you want to be below 120.
Since the language says price for households earning no more than, I just assumed 120 would be the only number mentioned in that moment. So is this just a little error where?
I think that's correct, Commissioner, and we'll make sure that's clear.
So in essence, it'll strike, there will be no 80 in there anywhere.
There's just a ceiling.
There's just a ceiling, okay, because the way I read right now, it looks like there's a ceiling and a floor, and at least what we're talking about is mostly it is just a ceiling. So I just want to make sure we are on with that. Okay, I worry a little bit, but if it's really just for the future, some other potentials, we have all of ours right now. They're all locked in. The next time they're sold, it still has to be to someone at 80, however many years, and the shared equity model, whatever, limited equity model. But those will still all be at the 80%.
Correct.
It's only future things, and because we already have a proper affordable housing property policy, like I said, it's potentially more so when we are offering a subsidy, not when we're transferring land.
And really, whenever you offer a subsidy, those stipulations will be in there anyway.
Right.
This contract is really just recognizing them as a CLT with the ability to
With
provide.
opening up the
Right.
potential for, okay. I think I'm comfortable with this. I think it worries me a little bit. But if it's mostly about the future, we still have the ability, and then it just means commissions have to go project by project, subsidy by subsidy, and see whether we really want to focus on under 80 or more of a workforce that we're looking at, and we still could support it. Okay. Thank you so much. Thank you, Mr. Mayor.
All right, thank you, Commissioner. Commissioner Book.
I think Commissioner Willetts actually just covered it all, and very good catch, because I wanted the same thing. Thank you.
Thank you, Commissioner. So I want to remind everyone, and tell me if I'm wrong on any of this, but this is not our only housing partner.
No.
We continue to partner with the Gainesville Housing Authority, with the Alachua County Housing Authority, with Habitat for Humanity, where we had a celebration this morning, with NHDC, and with anybody else who comes along that might fit the right model. So we continue to be available and to do much lower than 120% of AMI work with a variety of partners. The Hutchinson Foundation comes to mind as yet another that we currently work with. The community trust model often wants to do mixed income, and perhaps works best when there are a mix of incomes in their portfolio. So this keeps them from having an artificially low ceiling, which keeps them from acting like a normal community trust, in my understanding. Or is that mostly on track?
Yes, sir.
Okay. I feel completely comfortable with this, and for that reason. We're giving them flexibility to use best community trust practices nationwide, as well as continue to give us the option of restricting whatever we give them, whether it's money or land or any other resources. Not only them, but anyone that we enter into a housing agreement with, we continue to be able to offer case-by-case, contract-by-contract restrictions, and still allow them to operate in best practices for a community trust. So,
Correct.
all that said, have I missed anything? Are we good from your end? Okay.
Yes, sir.
Okay. Is there any public comment?
There's no public comment.
Okay. Thank you, Madam Clerk. Someone make a motion. Commissioner Eastman.
Yeah, thank you. I'd like to move 2025-783, the extension of agreement for the provision of community land trust services by Bright Community Trust.
Second.
We have a motion and a second. I see no further light, so all in favor, please say aye.
Aye.
Anyone opposed? All right, that passes unanimously. Madam Clerk.
Mr. Mayor, we're on
Thank you,
to,
Mr. Harris.
Mr. Mayor, we're on to 2025-784, stormwater and solid waste fee collection with the recommendation the General Policy Committee authorized the city manager to negotiate a new agreement with the GRU Authority for the collection of stormwater and solid waste fees.
Welcome, Mr. Singleton.
Good afternoon, Brian Singleton, Special Advisor for Infrastructure. Currently, fees for stormwater and solid waste are on the GRU bills. Those services are provided by the Public Works Department. Stormwater includes drainage needs for 415 miles of roadways, 70 acres of basins, 15 pump stations, 8,800 drainage structures, 190 miles of pipe, 95 miles of ditches, six bridges, mosquito control, and street sweeping. The solid waste cart fee rates include the weekly pickup for trash, recycling, yard waste, bulk weights, white goods for about 28,000 homes. Stormwater has been on the GRU bills since it was enacted in 1988. Solid waste predates that. This continues to be the preferred method for city staff and GRU staff to the mutual monetary benefits. At its March 2025 meeting, the GRU Authority directed its staff to work with the city to remove the fees from the GRU bills. However, the respective staffs have been discussing alternative arrangements to keep the fees on the bill due to the benefits. The most alternative feasible option to remove the fees from the bills would be a non-alvarellum assessment on the annual tax bill. The earliest is that this could occur would be for fiscal year 27 due to the statutory deadlines to impose such assessments. Public Works and the City Attorney's Office has been working on the required methodology studies and resolutions to move to the assessment process. Statute requires resolutions to be adopted by the end of this calendar year to appear on the November 2026 tax bill. As such, we are scheduling the resolution for the December 4th City Commission meeting if we are unable to make the alternative arrangements work out. The budgeted revenues for storm and solid waste cart rates is $23.8 million for fiscal year 26. The current MAU with GRU is a fixed fee for the collections and is approximately $825,000 for fiscal year 26. In comparison, changing to the tax bill, the impact is roughly for $1.47 million, which includes a 2% collection fee paid to the tax collector, an estimated $50,000 fee to the property appraiser, and a 4% statutory discount for early tax payments. Another item to consider is the city currently collects a little over $1 million from nonprofits and government properties for stormwater fees. These collections could be impacted by billing by the tax collector and would likely be a revenue loss. Another item to consider is changing the methodology is a risk and could be challenged by a lawsuit. We would have a strong case, however, there is time and effort associated with defending a lawsuit. Another impact is neighbors may experience challenges in paying a single annual bill versus a monthly bill. For a medium cart and a single storm ERU, the monthly cost for fiscal year 26 is $5,280 a month. Changing to a single annual payment would be $633.60. Staff has discussed the potential for standing up our own monthly billings, either through Public Works with Ms. Mowry or with Billing and Collections with Mr. Nguyen. It would likely cost more than the GRU fees due to the economy of scale that GRU has for billing services. We would likely be able to complete the effort less than the tax collector method, but there would be concerns with being able to collect standalone trash and storm bills due to the amount of non-permanent residents we have. And additionally, there's no feasible way to stop picking up trash for people who aren't paying or to stop providing storm services for people who aren't paying. Currently, staff has proposed to change the fee for collection from the fixed fee to 4% of revenues collected. This still needs to be fully negotiated with GRU and approved by the GRU authority. However, the feedback that we've received to date that this should be doable. The fee would increase from the $825,000 to approximately $952,000 for fiscal year 26, which is a significant savings from the tax method, considering the 2% fee paid to the tax collector, the 4% statutory savings, the $50K to the property appraiser, and then the revenue loss from governments and nonprofits. For the aforementioned reasons, staff recommends continuing to negotiate with GRU to keep the fees on the GRU bills, but we are looking for feedback from the commission on this topic. Staff recommendation is to authorize the city manager to negotiate a new agreement with the GRU authority for the collection of stormwater and solid waste fees.
Very good. Thank you, Mr. Singleton. Commissioner Chestnut.
I'd like to place a motion on the floor.
That's fine with me.
All right. The General Policy Committee authorizes the city manager to negotiate a new agreement with the GRU authority for the collection of stormwater and solid waste fees.
A motion and a second. Thank you, Commissioner Chestnut. Commissioner Eastman.
Yeah, thank you, Mr. Singleton. So, generally speaking, now most governments do not have a municipal utility that they are with. So most governments are on the ad valorem, right? Or do most governments utilize ad valorem, like the taxes to? I guess not ad valorem tax, but the tax collector to collect these fees. Is that the standard generally?
County does.
It's a mixture, depending on just the needs locally and the history behind the creation of the different jurisdictions. Remember, there's 67 counties and over 400 municipalities, so there's multiple ways everybody's doing it.
Okay. But it's, well, this seems like one of those classic, win-win situations. I mean, we'd be saving, with the what you have discussed with the GRU authority is about double what the tax collector is taking in terms of the administrative fees. So that's a good amount of money. That means that can go to lower rates at GRU. That means that can go more toward debt collection, like whatever the GRU authority wants to spend their money on, right? From our perspective, we save money just through all the kind of other odds stuff that occurs around the collection. Not doing this seems like what we're doing is it's mostly we're going to have to raise our fees up, right, to make up for the difference in the lost revenue, I would imagine, because this is a standalone enterprise fund, correct?
Correct. So stormwater and solid waste are both standalone funds. If we switch methodologies, we would either have to adjust our fee to account for the revenue losses and the increased costs, or reduce services.
Okay. So, and reducing services, people got to get their their garbage picked up. Stormwater is flooding. So generally speaking, we'd probably be increasing the fee amount to some amount, and that fee amount would also have to make up for the difference that mostly probably the University of Florida, I guess other governmental entities, the school board and University of Florida would not be paying anything, which they're already not paying property taxes.
State of
right?
Florida, ourselves.
Right.
But yes, stormwater is both flood protection, water quality, sandbags during hurricanes, and then, like I said, solid waste is the weekly trash, recycling, yard, bulk waste pickup.
Right. So essentially what we're saying is that GRU will get more money that they can use to keep rates lower, to have downward pressure on rates or debt or whatever they want to do with it. We save money. We don't subsidize some of our larger governmental entities like the University of Florida, like some of the other governmental entities and nonprofits that are within the area. It seems like a classic win-win situation. So, I'm happy to continue, looking at December. It seems like it is very standard to put this on the tax roll. So if we're not able to come to an agreement, I'm happy to come back here at that time as well. But I do think that it is better to try to save all of our ratepayers and our taxpayers money in the long run. And so I'm comfortable with the motion. Thank you, Mr. Mayor.
Thank you, Commissioner Eastman. Commissioner Willetts.
So our current agreement, did we sign we had agreement before the transfer or devolution? Do we have a current SLA? How do we currently, or is it still just sort of just running on autopilot?
It's in your backup. It is a MOU pre the authority, so it has an automatic renewal. GRU hasn't disputed it, so we are operating under.
Okay, for a total of 3 years. So we would. That's what I thought. I thought it said for 3 years. So we would be up next.
It renews automatically unless they let us know they would like to renegotiate it by, I believe, January every year.
And this has previously it's is it a 3% increase per year?
3% increase every year.
Would that probably be something similar? Well, in the future we would just do a 4%. So
4% of revenues collected. So
revenues.
as our rates adjust, their revenues would adjust.
Got it. Okay. So between 2025, just so that we look at the numbers, if we're currently at 824,000, let's say 825,000, and the proposed 952,000, but if it went up by 3% anyways, we would, from my quick calculation, that's an extra. Well, my calculation's gone now, but that's an extra $25,000 or so, just so that people know that we would be closer to 850,000 next year just by the 3%. So really, year to year, this is more like a $77,000 increase, not a closer to 100. Anyways, there's some math in there. Is all I'm saying. No, it's closer to $100,000 increase instead of 125. Just wanted to throw that in there. And so in March 2025, GRU authority directed their staff to and instructed us that they wanted to extricate this. But the conversation since has been with GRU staff or GRU authority, the board.
If I might intervene, it's actually been with Mr. Pilarski.
Okay.
He has been speaking with me in several emails saying that they were interested in reopening the conversation to have them continue doing it, and meaning continue to place it on their bill. And before they placed it back, they meaning GRU, placed it back on the GRUA agenda for consideration of continuing to do it, we thought that we needed to bring it back here before giving Mr. Belarski any additional.
So, but their board would have to approve this?
Yes.
Okay, that's all I kind of think all I wanted. And then if in the future, if UF, let's say, UFX, for example, wanted to have a payment in lieu of taxes for, or in lieu of fee, just for like something like stormwater, would that potentially be on a bill that then GRU collects a 4% on, or is that something that could be arranged in direct payment to the city? It's a crazy idea, but if UF wanted to hand us $500,000, I wouldn't want to pay 4% on it, is what I'm saying.
So we have a stormwater agreement with GRU that discussed part and supplement to the campus development agreement to contemplate which properties they pay into and which ones they don't. A lot of UF drains into Lake Alice, and Lake Alice doesn't pop off anywhere into our systems. So those properties draining there, does not make sense for them to pay our stormwater fees. But for their properties that don't go there, they do still pay stormwater fees.
Okay. I'm just trying to understand a little bit about that. Okay. They pay some, not all. That's for stormwater. Got it. Okay. Thank you so much. Thank you, Mr. Mayor.
Thank you, Commissioner Willets. So I'm going to vote for this, but with some reservation, with serious reservation. And this reservation is not directed toward GRU. We have a regular public commenter who often comes to talk about this. And in this one case, I agree with this person because the GRU bill that all of us get is large, not because any of the individual items on the bill are exceptionally large, but because altogether it's a big bill. And when you bundle 6 services on one bill and somebody has to pay all those things at once, that creates an impact on some of our neighbors. It has created an impact on me when I was younger and less able to pay bills. And we've all been in that circumstance, and I would love for us to find a way to separate some of that. I understand that when the bills were all bundled, it seemed like a really great idea. And for some folks, it works great. For people who bundle and pay all their bills at once, as I'm blessed to be able to do now, it's terrific. But it's not terrific for everybody. And it's a great big bill that you can't not pay. You don't have the option to say, I'm only going to pay this month, this part this month, and I'll catch that up later. It's not that any of this would go away for anybody. It still has to be paid, just on a little different schedule. And sometimes being able to do that on a little bit different schedule, a different paycheck during the month, makes all the difference in the world for somebody. Might keep their lights on and their water running. So I'm going to vote for this because we don't really have a lot of option. But I would love for us to find a way to do this differently in the future. Now, I've been saying that for several years now, and we haven't figured it out yet. So I don't know that there is a way for us to continue to get paid what I believe we're owed on as a city on stormwater and garbage collection. But I really want us to think about this because, again, for most folks, works fine. For some folks, it is a real backbreaker. And we ought to think about the idea of having 6 services bundled on one bill. So thanks for that. Is there any public comment on this?
There's no public comment.
All right, come back to us. I don't see any lights. All in favor, please say aye. Aye. Any opposed? All right, that passes unanimously. Madam Clerk, thank you very much, Mr. Singleton, and all Public Works staff here with us today. We're going to take a 10-minute break while I read the contract language because I haven't had a chance to read it. And we'll come back here at 3:35. Welcome back, everyone. We are broadcasting again, and Madam Clerk, why don't you go ahead and read this back into the record just to make sure we're on track?
Mr. Mayor, we are returning to 2025-746 Interim City Manager Employment Agreement with the recommendation the General Policy Committee approve the employment agreement with Mr. Persons and to authorize the mayor to execute the agreement subject to approval to the city attorney as to form and legality.
Very good, thank you. And is this your motion, Commissioner Book, or?
Yes, sir, I believe it was, and all they have done is add a line that talks about clarification without materially changing the agreement, and so I would move approval of 2025-746 with this minor clarification provided by the city attorney.
Very good, and do we have a motion and a second? Have we had public comment on this? I don't think we did.
We do not have public comment.
Okay. All right, so to be clear, we have asked for a public comment, but there is no one signed up.
That's correct.
Okay, very good. All right, Commissioner Engel.
Has this contract been checked for pre-positive modifiers?
I'm confident that this contract will provide the basis for a very fruitful relationship.
Very good. Thank you very much.
Very good. Mr. Persons, you're still on track here with this? All right, okay. You should be. All right, see no further lights. All in favor, please say aye. Aye. Any opposed? All right, that passes unanimously. Congratulations, Mr. Persons. Happy to have you on board. Thanks. All right, Madam Clerk.
We are on to member comment.
Any member comment? Commissioner Book.
Thank you, Mr. Mayor. I was just asking the manager if she could tell us or have staff tell us a little bit about next week's special meeting so that the community is kind of fully informed.
Yes, sir, Mr. Mayor, on October 2nd, I have scheduled a meeting at Ironwood Golf Course. It's 8 o'clock. It really is a staff meeting, but it is a transition subject matter that Andrew and I will lead, working with the senior leadership, all of my department directors. It'll be really a strategic planning 2026 agenda setting meeting. And Andrew and I will lead the first half of it, starting at 8 and probably ending somewhere around 11:30ish. We'll break for lunch. And then the second half of the day, we'll have a couple of panel discussions that will integrate community leadership. The first session will be moderated by Andrew, and it will be with our business partners for the most part, large organizational partners, UF, Santa Fe, Alachua County Schools, the Sheriff's Office. The second meeting will be moderated by John Alexander. It'll be a community civic-oriented panel discussion. We're going to create questions that'll be, not just regular kind of challenging questions we want to generate so we can get some good conversation. But that second panel will have, I believe we've identified, help me, John, we have 4 individuals. I think Pastor Rawls is one of the individuals. Rodney Long is one of the individuals. Commissioner Hayes Santos, because he can stir things up, just being specific about that particular one. He is on the panel, and Virginia Grant is on the panel, and we were considering someone else, but again, that's kind of how the panels are shaping up. And then we'll end the day. I wanted to have Kristen advertise it as a publicly calendared meeting because I did not want to exclude commissioners in case you wanted to come. There's no expectation that we would be asking you to approve anything, but we would, I would be interested, Andrew would be interested, just if you wanted to come and be in earshot of conversations and ask us questions.
Yeah, and it is not, to be clear, there's no expectation of decision-making or presentations by commissioners. It is, we've been invited, and we thought it best to
The sunshine,
it, just
because,
so.
yeah, more than one might show up, and I didn't want any issues with, the sunshine. It was all about sunshine, really.
Thank you, Madam Manager.
All right, very good. I appreciate everyone's time and attention. We went through quite a lot today. There's a lot to be done, and it's a good start to. Depending on how you think about it, a good end to the fiscal year, a good beginning to the fiscal year. We passed the budget yesterday, so here we are. Thank you very much for your time and attention. And we do not have a meeting next Thursday, so we'll be back in here the week after. Thank you.